Picture this: a livestock farmer standing at the edge of a pasture that's lush, green, and technically classified as a wetland. Should that patch of soggy land fall under federal protection? Or should farmers be free to manage their property as they see fit? That deceptively simple question sits at the heart of a deeply complex and often controversial debate surrounding wetlands protections in the United States, particularly after a major regulatory shift in recent years. The Trump administration's decision to roll back federal protections for many wetlands and waterways sparked cheers from some in agriculture, especially livestock producers, but raised alarm bells among environmentalists, scientists, and local communities concerned about water quality and ecosystem loss. So what exactly changed? Why does it matter? And who gains or loses from all of this? Let's unpack it together. What are wetlands, and why do they matter? Wetlands might not look like much at first glance. Just soggy lowlands, maybe filled with cattails, frogs, and bugs. But they are some of the most ecologically important landscapes on Earth. Here's what makes them crucial: natural water filters. Wetlands trap sediment, absorb pollutants, and clean water before it flows into rivers and groundwater. Flood control buffers. Like sponges, wetlands soak up excess rainwater, helping to prevent flooding. Biodiversity hotspots. They're home to countless species of fish, birds, amphibians, and plants. Carbon sinks. Wetlands store vast amounts of carbon, playing a role in climate regulation. Historically, the U.S. has lost over half of its wetlands to development, agriculture, and infrastructure. That's where federal protections come in, aiming to preserve what's left. How wetlands came under federal protection in the first place. The backbone of wetlands protection in the U.S. is the Clean Water Act, CWA, of 1972. Which gave the federal government authority to regulate pollution in navigable waters, a phrase that has proven controversial and legally murky. Over time, the definition of what counts as waters of the United States, or WOTUS, has shifted back and forth through presidential administrations, court cases, and rulemaking processes. In essence, the big question has been, do wetlands count as navigable waters? Under Obama-era rules, the definition was expanded to cover many streams, ponds, and wetlands that fed into larger bodies of water, even if they weren't permanently flowing. This meant stricter oversight for those lands, permits, restrictions, environmental reviews, especially if they were altered for development or agriculture. Enter the livestock farmers. Why this matters on the ground. For cattle ranchers, hog farmers, and others in livestock agriculture, these definitions matter immensely. Many livestock farms operate on large tracts of rural land where intermittent streams or marshy areas might appear seasonally. Under expanded federal rules, these areas could fall under regulation, limiting how the land could be used, whether for building barns, draining fields, creating manure storage, or expanding grazing areas. From the farmer's perspective, these rules create uncertainty about what's regulated and what's not, can lead to expensive delays and permitting battles. Feel like federal overreach into private land management. So when the Trump administration rolled back the broader Obama-era WOTUS definition in 2020 with the Navigable Waters Protection Rule, NWPR, many livestock farmers and agricultural groups celebrated. Suddenly, countless acres of wetlands and tributaries were no longer federally regulated. But not everyone was thrilled. The Navigable Waters Protection Rule. What changed in 2020? When the Trump administration introduced the Navigable Waters Protection Rule, NWPR, in 2020, the landscape of U.S. water protections dramatically shifted. This new rule narrowed the definition of federally protected waters, effectively removing millions of miles of ephemeral streams, which only flow after rainfall, and wetlands not directly connected to larger bodies of water from federal oversight. Under this rule, ephemeral streams lost protection, even though they feed into larger water systems. Isolated wetlands, those without a surface connection to a navigable body of water, were no longer covered. Farmers no longer needed federal permits to alter or develop these areas. In practical terms, this meant livestock farmers could expand infrastructure, build access roads, or change grazing patterns on land previously considered protected wetland, without going through the red tape of federal approval. Many in agriculture saw it as a long overdue correction to what they viewed as unclear and overreaching rules from previous administrations. But while the NWPR simplified life for some landowners, it alarmed scientists and conservationists. Environmental concerns beyond the farm gate. Environmental groups and researchers warned that the rollback could have long-term consequences. Water quality risks, unregulated development near wetlands could lead to more agricultural runoff, nutrients, manure, pesticides, polluting rivers and drinking water supplies. Habitat loss. Wetlands provide critical breeding grounds and shelters for countless species. Shrinking these protected zones could push already vulnerable species toward extinction. Flood vulnerability. With fewer wetlands acting as sponges, nearby towns and cities could become more susceptible to flooding events. Climate implications. Wetlands act as carbon sinks. Drain or degrade them, and that stored carbon gets released, contributing to greenhouse gas emissions. One study from the Environmental Law and Policy Center estimated that the NWPR removed protections from over 51% of wetlands nationwide. That's not just bureaucratic change, it's ecological upheaval. Balancing act. Farmers, freedom, and the land. For many livestock producers, the rollback was welcomed as a return to common sense. Groups like the American Farm Bureau Federation and National Cattlemen's Beef Association supported the NWPR, arguing that it allowed farmers to manage their land without fear of accidental violations or costly permitting delays. One Iowa rancher put it simply, "It felt like we had a federal agency telling us we couldn't fix a pothole without an environmental impact study. That's not practical for a working farm." Still, not all farmers agreed. Some expressed concerns that losing wetlands protections could hurt downstream communities, especially when combined with rising fertilizer use, heavy rains, or droughts. There's an uncomfortable truth here. What helps one farm may harm another, especially if pollution or flooding crosses property lines. Legal challenges and the road to SCOTUS. As with many major environmental regulations, the NWPR didn't pass quietly. Environmental organizations filed lawsuits in multiple states, claiming the rule, violated the intent of the Clean Water Act, ignored science about how interconnected water systems really are, undermined protections for drinking water and habitat. Several lower courts initially upheld the rule, but others issued temporary blocks or stays, especially as evidence grew that the rule might lead to pollution hotspots. Things came to a head when a 2023 Supreme Court case, Sackett v. EPA, delivered a ruling that effectively narrowed the definition of protected wetlands even further, cementing some aspects of the NWPR's philosophy even after the rule itself was scrapped by the Biden administration. What's happening now? After taking office, the Biden administration repealed the NWPR and worked to craft a new WOTUS definition, one that balanced science, clarity, and stakeholder concerns. In early 2023, the EPA and Army Corps of Engineers released a new rule restoring some pre-2015 protections, but leaving out the most expansive Obama-era definitions. However, the Supreme Court's ruling in Sackett v. EPA limited how far agencies can go in regulating wetlands, especially those that aren't visibly connected to surface waters. So while some protections have returned, the regulatory landscape remains murky and politically charged. States are increasingly stepping in with their own standards, creating a patchwork of rules across the country. A story in the soil, real lives, real consequences. Let's bring this down to earth. In California's Central Valley, a dairy farmer expanded operations into a former floodplain now drained and used for feed crop. Under NWPR, no permit was needed. Meanwhile, across the state line, a fishing guide in Oregon noticed algae blooms choking streams fed by runoff from upstream livestock farms, now unregulated. One thrives. One struggles. Both are connected by policy and water. These aren't abstract debates. They're decisions that play out in streams, lungs, crops, and drinking water every day. Conclusion: a question of values. At its core, this debate is about balance. The right of farmers to manage their land versus the responsibility to protect shared resources. Short-term agricultural freedom versus long-term ecological resilience. Local autonomy versus federal oversight. There's no perfect line to draw, but drawing no line at all could leave us with fewer wetlands, dirtier water, and a warming world. As we move forward, one thing's clear. How we treat our wetlands says a lot about how we value the land and each other.